Hello, beautiful people. Welcome to my 3,000 subscriber special video, encore presentation of episode 1. It's Tommy V in Michigan, and yes, for those wondering, that's how I say it. I'll still answer to Tommy V in MI, but the MI is for Michigan. Go Blue. Beat Alabama. So I wanted to thank a lot of people, and I was going to go through a whole list of the Discord and the channels that have used my content and shouted me out, and the regular viewers. But here's the thing. I have a terrible memory. So if I named 15 people, I know I'd forget 15 more. So you all know who you are. You mean the world to me. Anybody who's ever left a chat, anybody who's ever been in a live stream, anybody who's commented on a community post, anybody who's left us, I think I said super chat, but speaking of super chats, if in the next 3 hours or so, I can figure out how to use StreamYards or Streamlabs, maybe we can put those on screen while we're watching this clip, because this part right here, to be totally honest with you, this is not live. This is pre-recorded because no way in hell I'm going live the first time I'm ever on camera. So, with that being said, we got a very interesting one today. It was my first clip. I put it up with no commentary, no nothing, no intro, no thumbnail. It was just a clip I found. I thought it was fascinating. It's about 1 hour and 7 minutes, and it is a child support case out of Georgia, where mom says that dad is behind on child support, when maybe there was a few months he didn't have to pay, and there was a reason for that, and oh shucks, it sounds like she forgot, and now it's coming out of his paycheck. Dad got a lawyer, and boy, the judge is not happy. I'll be honest, takes a few minutes to get going, but you know me in the clips that I do, there's a moment, there's always that moment you're like, oh, that's something different. And like I said, this one only has about 1,300 views, which is a good number, but I really think this is one of the best clips I ever cut. So I want you to enjoy it, and I'll see you on the back end. Enjoy the show.
Versus Older Color Corolla. All right. Miss Color Corolla, good morning. She was on the call.
Good morning.
Color Corolla, how are you?
Morning, Judge. I'm doing well, and yourself?
I'm doing just fine. And I see Attorney St. Fleur, who represents Mr. Olu Color Corolla. And I see Mr. Color Corolla. Good morning, Mr. Color Corolla. How are you? All right.
Sorry, speaking on mute. Good morning, Judge.
Good morning. All right, Miss Color Corolla. You filed a petition for contempt before this court. How much time? Well, it's just us. So, all right. You ready to proceed, Ms. Color Corolla?
Yes, Judge.
All right. Attorney St. Fleur, you ready?
Yes, Your Honor.
Okay. All right. Go ahead and swear, everybody. Go ahead and raise your right hand, Ms. Color Corolla. Do you solemnly swear or affirm that the testimony you're about to give to this court is the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You may proceed, Ms. Color Corolla.
Okay, Judge. Your Honor, I'm here essentially on 2 issues, or actually 3 issues. On October 4th, we finalized our divorce decree in front of you, referencing issues in regards to child support as well as personal finances. The issue that I'm bringing before you today is essentially related to arrears in regards to child support, as well as the lack of fulfillment of the personal finance matters in regards to our rental property. there's a difference of about $4,090.20. I'm referring to Exhibit 1 in regards to just trying to break this down simply so that I can be respectful of your time and everybody else's time. It's really two separate issues of value less than $1,500 in my eyes. But it's just a matter of, I want to make sure that we're adhering to the orders as stated in regards to taking care of the children per the order, as well as how we should be dividing our assets and paying them out in regards to what is owed to each other. So if I can refer to just Exhibit 1, and forgive me if I'm shaking when I'm speaking. My issue is mainly just wanting the difference between what I owed Mr. Colacarolo and what was owed to me for the unpaid equity, our rental property, to be paid out. And I believe in prior communications that I can refer to here, Mr. Colacarolo agreed that the difference between those two things is $970.56, and what would be paid out to me in terms of a difference. So essentially that I'm before you today to just present that as a request for that to be adhered to as it was stated in the order. Secondarily, the issue in regards to child support. We were before you once again in October, and there was a temporary order in place in regards to how the August and September child support was to be paid out, and that is in Ms. St. Flora's Exhibit R4, page 3. The last page refers to the stock that was in our shared assets. All that was divided per the order correctly, 60-40, no issue there. However, on the 4th of October, we discussed the fact that the funds in that account did not match the $5,000 that was stated. And at that time, Ms. Coleman, my attorney, referenced to that point. And because it was $5,000 and the amount that it was actually paid out was $2,500, that the payments that would then come on that date that you ordered would be for child support for September and then October, because October was then past due at the time of our hearing. So therefore, that monies was never paid out. Well, that money, excuse me, I apologize. It was paid out in the amount of $2,814 in October, which Mr. Colacarolo is calling a shadow loan. However, it was essentially just, I don't know what a shadow loan is, so it might be helpful if they define that for me, but you essentially ordered him to pay the equivalent of what was missing in the Fidelity account as child support. That subsequently also would show child support income for, at the time, what was a necessary part of my home loan process. That process never went through. I was able to secure my home, so that was no longer an issue. But we do have the matter of the missing child support. In an effort, I guess, to essentially make himself whole, or to do the math in a way that I could not necessarily understand, I was only paid child support of $1,104. Excuse me, I was only paid child support of $606, which is Exhibit 2, and it's a $1,104 difference to what was ordered in your final order. And I can refer to that if necessary as well. But that is essentially where we are dividing in terms of what is to be paid out and what is not owed. So I'm asserting that essentially anything that was prior to our order, prior to October 4th, was dealt with. And therefore, anything afterwards in your final decree, in which you stated that the child support amount was $1,710, should be paid according to the final order and not according to any other calculations, because according to our child support order, no changes in child support can be made in Exhibit 6 without the court's order. So you had already told us what the amount was. That support amount should have been paid, and it was not. I was shorted $1,104 for the provision of my children. So those are my main two issues that I'm bringing before you, Judge. Tertiarily, there are medical bills that are still unpaid, but I would like us to focus in the interest of time on just the child support issue, as well as the division of the personal property, which we both agree is the difference of $978.56.
Thank you, Ms. Colacarolo. Attorney St. Fleur?
Yes, Your Honor. Good morning. Your Honor, I will say this, Your Honor, we've been before you numerous times. Your Honor, we cannot ignore the temporary orders. It was actually 3 orders, Your Honor, temporary orders. One that dealt with the summer visitation, Your Honor, and 2, the first and the second temp order that dealt with specifically finances, Your Honor. And I will say this, Your Honor, as far as the second temporary order, Your Honor, that was dated on 8/24. Your Honor, we were before you, and I also have the transcripts, Your Honor, and it's only a few lines that I would ask that we will refer to, Your Honor, at that time when we were before you. Attorney Prabula was the attorney, Your Honor, when we came to you. It's actually the first and the second temp order, Your Honor. There was a Fidelity account, Your Honor. It was stocks, and in that Fidelity account, in the May order, temporary order, you stated that the parties, you apportioned that, it was roughly $27,000, Your Honor, in May. And you apportioned it 60-40. Mr. Corolla was to get 60, Ms. Corolla was supposed to get 40. Your Honor, she did get, it was like maybe 22,000 that he was able to cash out. She got that portion. There was no issue. Your Honor, when she got that portion, mind you, just to give a little background, this was the matter where Ms. Corolla, she unilaterally decided no longer work. And Mr. Corolla was, supporting the children and the family primarily on his own. Your Honor, in January, he experienced some health issues, Your Honor, and even on his decreased salary, Your Honor, he was covering and paying for everything while Ms. Corolla was not working at all. But needless to say, Your Honor, in his obligation, Your Honor, he has never failed to care for his children. But needless to say, to go back to the Fidelity account, Your Honor, for the first temporary order, you stated that it was supposed to be a 60-40. He was able to give her a portion of that, Your Honor. But when we came back to you, Your Honor, we were here on August 9th, 2022, Your Honor, for a status conference. We represented to the court that it was a Kiwi stock, Your Honor, that my client could not sell. And Ms. Prabula, she stated, and Your Honor, it's in the transcripts that I have as my Exhibit 5, Your Honor, she stated that Ms. Corolla represented to the court that she could get $5,000. Your Honor, we never put a value on how much the Kiwi stock was, Your Honor. And in the second temporary order, Your Honor, if we specifically look at Provision 2, Section 3, it states that the father shall pay the mortgage for August and September 2022, which shall be considered a portion of his child support obligation. Your Honor, at that time, the marital residence was $3,966. Your Honor, that was before it was sold. Then, Your Honor, in that same temporary order, Provision 5, it says Fidelity account. It states, in its May, and I'm going to say 26, 2022 temporary order, the court ordered that this account could be split with the mother receiving 40% and father receiving 60%, subject to request for further accounting. All but $5,000 in stock was withdrawn. Mother may retain the $5,000 in proceeds from the sale of stock in this account as child support for August and September. So, Your Honor, it's in the transcript that the mortgage and the Fidelity account was going to be considered child support. Your Honor, you never prior to that time, my client was only paying $1,407, but he was paying all of the expenses. You were very clear that in August, Ms. Corolla was going to have to get a job and start paying her fees. So, Your Honor, it's unclear how today Ms. Corolla is saying she didn't receive child support for September, Your Honor, when Provision 2G and Provision 5 of the second temporary order specifically states that Mr. Corolla was going to pay the mortgage and pay the Fidelity, and they represented, Your Honor, that she could get $5,000 from the Fidelity account. We never represented that, Your Honor, and that's in the transcripts. Simply because she did not get the $5,000, my client still met the obligation of paying the mortgage for August and September. So the fact that now she's stating that she did not receive September child support, it's unfounded, Your Honor, and it's being disingenuous to the court, Your Honor. August and September was paid. Then, Your Honor, we came here on October 4th for our for the final hearing. When we came here, Your Honor, there was an issue regarding her receiving. She was trying to qualify to get a home. So with that being said, Your Honor, we did go off record where it was in a way to assist Miss Cola Corolla to try to help her get the loan or to get her house approved. And Your Honor, I'm not sure the court remembers, but it was hey, can you pulled everyone aside and said, hey, is there any way that we could try to help Miss Cola Corolla? On that day, Your Honor, my client transferred 2814 on October 4th, and it's in Miss Corolla's Exhibit 5, Your Honor. It's directly in the email chain. It's in her Exhibit 5. Mr. Cola Corolla sends her 2814, Your Honor, on that day, 10-4. Your Honor, he did not wait for a court order. He sent her 2814. Your Honor, he called it a shadow loan because it was to complete his October child support payment and his November payment. Your Honor, he was doing this simply to help her qualify for her home. So he technically gave her, I'm not going to say, he gave her portion of the November child support obligation early. So, Your Honor, if we do the math, his child support obligation is only $1,710. He gave her $2,814 on October 4th. It's our position that August and September child support has already been paid through, mind you, Your Honor, there's also a Range Rover that Mr. Cola Corolla also paid during that time. So my client paid for the Range Rover in August and September. He paid for the mortgage in August and September. And also the Fidelity account is what Attorney Perbula stated that that Miss Cola Corolla, she wanted to have, Your Honor. And also, I just want to back up slightly. With the Fidelity account, you apportioned 60-40. Whatever Miss Cola Corolla received in September, she never gave my client 60-40. It's a reason why she kept it. Your Honor, she kept it because it was child support. It's a reason why. So it's unclear, Your Honor, why now she's saying she didn't receive anything for September when, Your Honor, the order is clear and the transcript is very clear. But needless to say, Your Honor, in October, Mr. Corolla sends her 2814, Your Honor, on October 4th. Your Honor, if we do the math, 2814 minus 1710 for the October child support. In November, there was a balance of 606 because he paid her early in October. That's why, Your Honor, he only gave her 606. Your Honor, there's no lack in child support. Your Honor, we've been before you for almost a year. My client has never shortchanged his kids. Your Honor, my client has always provided for his kids. Your Honor, so that's why, Your Honor, there's a 606 payment in November because he made the early payment in October. In November, Your Honor, you'll see the Zelle of 1710. In December, he paid 1710. In January, he paid 1710. In February, Your Honor, my client has never skipped a beat in providing for his children. Your Honor, then per the child support addendum, there's no need for income deduction order. My client pays his child support. Miss Corolla, she fraudulently went to child support services and said, Your Honor, we have an affidavit we have a letter from child support services saying that Mr. Corolla owes $10,000 in child support. Your Honor, $10,000. And I will say this, it may have been an error on child support part. However, Miss Cola Corolla had on her own initiative, she incited an IDO. Pointless, Your Honor. Mr. Cola Corolla has been paying now in March and April. Miss Corolla has been Mr. Corolla has been paying child support out of pocket. The IDO kicks in April. Your Honor, now Miss Corolla owes my client $25.65 of child support because she's been overpaid. Now Your Honor, this $25.65 covers the equity amount. Your Honor, we have no dispute about the equity amount. The equity amount was $40.90, Your Honor. But if we go back to the final judgment and decree, Miss Cola Corolla had to reimburse Mr. Corolla $2,000 for the guardian ad litem. Miss Corolla had to reimburse my client for the $1,000 $1,029 Range Rover payment. So, Your Honor, they've been doing hand over fist with money, but as of today is concerned, Miss Cola Corolla is made whole. She owes my client $25.65 for overpayments of child support. Your Honor, my client, he's disgruntled about the income deduction order because there is no need for the IDO. There was no need for Miss Corolla to go to child support services because child support payments has been made in full. Your Honor, he wants to cease the IDO immediately. But needless to say, Your Honor, it's our position. The 1710 child support, Your Honor, has been paid October, November to current, Your Honor, and now there is $25.65 that Miss Cola Corolla has that's due to my client. And Your Honor, I will say this in reference to this retirement and the quadro, Your Honor, Miss Corolla has unclean hands. Your Honor, your order states that after 30 days after the final judgment and decree, Your Honor, the final judgment and decree is dated for October 24th. Both parties were supposed to transfer retirement accounts. Your Honor, Attorney Perbula and Attorney Coleman, they have all of Mr. Cola Corolla's retirement accounts. As of date, Ms. Corolla has not given us any of her retirement documents, none, Your Honor. And she had technically, I think it was 90 days for her to get the quadro done. Your Honor, she hasn't been able to do it. She has not completed that obligation, but yet and still in her petition, she's saying that she's owed $4,000. Your Honor, that's not right. But needless to say,
she's saying that now it's $978.
$978, Your Honor, because that is a wash after the amount that I paid him. Oh, I apologize.
Go ahead, Attorney Sam.
Yes, Your Honor, that's Your Honor, that's not Your Honor. Your Honor, 978 has been paid. It has been paid, Your Honor, after the overpayment. Let me say, it's been paid after the overpayment. Your Honor, in April, Mr. Cola Corolla gave her a full amount of child support. Then his job gave her a half amount because the IDO kicked in April. In May, without my client knowing, in May, he gave her a full child support payment of $1,710, and his job is going to give her he has given her a half of that child support, Your Honor. So as of today, the only money that is owed is due to my client, Your Honor. That's $25.65. She has been made whole completely. But Your Honor, I will say this, her getting the IDO was under false pretense. Your Honor, August and September in the temporary order in the second, it's clear it's been done. So and if we review Ms. Corolla's Exhibit 5, she states to him, she was like, you're in arrears for not paying 2 months. Your Honor, the 2 months she's referring is August and September. Your Honor, in the second temporary order, it's been done. The second temporary order, it's been done, Your Honor. My client has paid for his children every month.
Okay. All right. So right now, according to, I'm assuming that was your opening, Attorney Sam.
Yes, Your Honor.
May I respond?
No. So I just want to make sure that we're all on the same page. The issue right now is $978.45, according to Ms. Cola Corolla.
978.56, yes, ma'am.
56. I'm sorry, 978.56. And money due regarding the Memorial Drive address, correct?
Yes, the
Okay,
978
so
is the difference between the two.
The difference between the two, what he's owed,
What I earlier,
Yes, ma'am.
as well as child support in the amount of,
$2.
so we're $248. So we're in court for $978.56 and $248. I just want to make sure we're all on the same page.
Up until yesterday, it was more than that, but the deduction did kick in and I received a card. So I'm giving that credit towards the $1,104 that was owed to me for November because no changes were to be made per the court order.
So this is going to be very unorthodox, but my question to you, Ms. Cola Corolla, why did you do an IDO in the first?
Yes, because per the orders, it only took one missed payment. One. It's the principal because this is something that is on his own volition, and there were supposed to be no changes made to child support. I was not expecting, nor was there any reason for it to be changed to $606 when the court order said $1,710. And so therefore I went to the child support office. I provided my documentation in Exhibit 3, and I essentially provided them that the balance due was $1,104.
But
We made the
essence,
October
no,
payment of
wait,
$1,700.
wait. The fact that he sent $600 and explained to you, in his view, that he had overpaid for certain items in the previous months that you took advantage of. That's why he.
No, his explanation was,
no.
I
What was his
apologize.
explanation? Go ahead. What did he tell you? His explanation was,
Per Exhibit R1, his explanation was that he provided me a shadow loan. And this is where we diverge in terms of our understanding of what happened on October 4th. On October 4th,
what did you think a shadow loan was for? Just
it wasn't a loan. That was payment of what I was owed based on the temporary order, Your Honor. The Fidelity account, Attorney Coleman on October 4th pointed out to you that the Fidelity account withdrawal, yes, it was split 60-40. He received his 60, I received my 40. The 5,000 in Kiwi stock, I was not able to immediately sell. I was only able to receive 2,500. But because you specifically put in the order 5,000, I was to be made whole the remaining 2,500. In addition to the fact that, yes, at the time, I did need to show child support consistency for a home loan. That was provided in the amount of $2,814 for September and October. August, I was made whole. I have no qualms about that. However, the short change in the 2,500 that was missing from the Fidelity sale of the Kiwi stock was to be made up because the $5,000 that was referenced in the the $5,000 that was referenced in the temporary order, because of the specified amount, it needed to be made whole to the 5,000. So therefore, the 2,800 that was provided to me was to be representing income or representing child support, which he then referred to in his message to me and our family was an Exhibit 4. He also referred to it as proof of child support. So I understand that he's calling it income or calling it a favor, but we all were under the impression that this was child support per Exhibit 4 in that second paragraph there. So therefore, he was making up for child support for September and October, and that is how I was treating it. So to shortchange me in November, knowing that the order clearly states any modification in child support needs to come from the court order, and no modification was provided. That was an independent decision made by Mr. Colacarolo and then communicated down to me. That is not something that I felt was appropriate. I waited and I sent him several messages in regards to this not being appropriate, this not being a good decision, that I will pursue further action. This is a matter of accountability. So therefore, that is why we're here on the child support issue. Blending child support and personal finances, I don't think, at least I don't want to treat it that way, because that's how you do get all of these very interesting numbers that were provided. But on the child support piece of this, it was $1,104. I went to DCSS to open the case because I was short of child support, period.
Okay, let's say you did. So why did you continue to accept money from him, knowing you had an IDO that was getting ready to come out of his account?
I did not initiate the IDO until March, ma'am. I was shorted in November of 2022.
So when you start getting the income deduction, why did you continue to, again,
because he was paying on time for all the other months. But if you are in arrears $1,104, I'm waiting for you to make the $1,104 whole. I mean, he's depositing the money for the remaining months as he should. I mean, I filled out the arrearage affidavit correctly. It was accepted. It was reviewed. I provided the info. That's in Exhibit 3. I never asserted that he owed me $10,000. I asserted that he owed me $1,104, which is clearly stated on the total due line. And this was done in March 31st. I've been waiting since November, having this conversation back and forth off and on with Mr. Colacarolo, that no changes were to be made per the order. You were to pay $1,710. That is what is expected for child support for 2 children. And I mean, and I, not to mention all the other things that I take care of for the children, but ultimately, that's all I was expecting. If you are in arrears, make up your arrears and continue to pay on time, which which is all I want. I don't want to have conversations about money. I do not want to be here. It's just a matter of, this is what the order states. Please continue to follow the order. No changes were meant to be made. That, at least that was an independent decision that was made, and I don't see how that's appropriate.
So you so again, I guess I'm looking at all of the orders, Ms. Cole, and I need for you to point out exactly where in the order that you're saying he didn't comply with. Which order and we're in the order.
Okay.
Because I mean, as we sit here, there been, I mean, it's
So,
according to your own
child
statement, you've done stuff that he hasn't filed contempt for, which he could for your non-compliance. So I guess I'm trying to understand where
on child support,
yes.
for child support, we're treating child support as a separate issue. So I'm looking at
Okay.
Exhibit 6, where you told me that the amount is $1,710
What
month
order are
over
you
month.
referring to? Give me 1 second.
I'm sorry, child support addendum, Exhibit 6.
Okay, hold on. Okay, go ahead. I'm looking at it. Go ahead.
Okay, I'm just referring to just the amount on line 4. So the child support addendum, bullet point 4, child support amount. Father
Okay.
shall pay $1,710 per month to the mother for the support of the minor children. This is beginning on October 15th. So
Okay.
anything prior to that was when we were under temporary orders. I understand the fidelity issue made things a bit muddy, but there was no provision, no text indicating that he was allowed to change the child support amount in November in regards to, there was no text, there was no provision for that. I am following the order as stated for the child support addendum that was entered. So that is part one. The other part of the order, in regards to IDO, second page of that same exhibit, part 2 of 13, upon the accrual of delinquency of equal to 1 month support, I'll give you, it's not 1,710, Your Honor, but I've been waiting since November for him to make November 1,710. It never happened despite my asking. This is about child support. The other part in Exhibit 7, the parenting plan suggests on the final page of the signed order, part 2, on that same page, custody and child support may only be lawfully modified by the court order. You did not issue an order that allowed him to reduce child support to $660. That is why I filed
I
the
have a
child support.
question. So have you paid him what you owe him?
We discussed that.
I just
and
need you to answer the question, yes or no.
The answer is no, because he
Okay,
owes
so
me more than what I owe him.
Stop right there. So you want me to order him to pay you, even though you still owe him?
Your Honor, I was under the impression that child support and personal finances were treated 2 different ways, because child support is for the children. Our personal finances are between 2 adults.
Again, you still owe him.
Your
But
Honor.
No.
Yes.
I'm just trying to, because he hasn't filed a contempt, which he could.
Yes, he could.
See, this is what I mean when people have the power to do something, and just because you have the power doesn't mean you have to use it or exert it. Ms. Cola Corolla, I
didn't say anything.
No, let me finish. So I'm not even getting attorney into this. So how much does Ms. Cola Corolla owe Mr. Cola Corolla? At this point, I just need a number. I just need a number. I don't need a whole paragraph. I need a number.
2565, Your Honor.
Are you stating the amount that would be owed to him based on their calculations or based on the orders? Based on the orders from October, I was to pay him $3,111.64, and he was to pay me $4,090, which create the wash of $978.56.
But have you paid him?
I haven't. He has not paid me my equity in 2424. He owes me $4,090. I owe him $311. That would be a payment to me of $978. That's how I discussed that with him and our family wizard so that this could not be an issue. But he would continue to disagree that the amount that you stated in the final order was $4,090.20. I'm just following the order as you stated it. I
know,
don't,
but you're not following the order what I said, what you paying him.
I'm happy to pay him $3,000 and he can pay me $4,090.
When are you going to do
He'll
that?
pay me $4,090 and I'll pay him $3,011.
No. When are you going to pay him?
When he pays me $4,090, Your Honor, as stated per your order.
So I'm just trying to understand, regardless of what you owe him, you want me, Miss Corolla.
So what
I'm not asking, no response is not necessary. Not necessary.
Okay, I apologize, Your Honor.
Let it go. Let it go. So as far as what was the equity amount that was? But oh wait, I forgot. You said Attorney St. Fleur, Mr. Corolla agrees with Ms. Corolla about the 978.56.
Yes, Your Honor. With the number that we stipulate to that, Your Honor.
Okay, so that number he still owes her.
Well, Your Honor, it's the way it, because she owes him the guardian litem fees, Your Honor, and the Range Rover. So the difference, Your Honor, from the 4,090 and
40/90/20.
40/90/20, Your Honor, and the 3,000 that she owes him, that's where we get the 978 from, Your Honor. She's been paid that with the overage in child support. She's been paid that now. I will say this, I will concede that it was not paid prior to the overage. We will say that it wasn't paid. However, there was the difference between the 978. She's been paid that. It's our position that it goes back to the arrears in September. Can you tell us what your decision is about September? Your Honor, if I can just pull up the transcript from her attorney. May I share my screen, Your Honor?
No.
That's prior to October.
No.
It's about the arrears, Your Honor. This started off with the arrears, Your Honor. That's the umbrella. She's saying that my client did not give her child support for September. Your Honor, the second temporary order is clear. Your Honor, honestly, as far as the fidelity account, I'm not saying she takes the loss, but she takes the loss that she could not get the $5,000. My client was very clear. That he could not cash out the quickie stop. Attorney Perbula said, my client believes she can get $5,000. Your Honor, in the transcripts from our hearing, Ms. Perbula says, Your Honor, it's on page 22 and 23. She says, Ms. Corolla has been able, she believes, to get them to sell that and cash that out. The court has agreed that Ms. Corolla will retain the entire $5,000 as child support for August and September, even though the court had previously split it's 60-40. It's one of those things, like, Your Honor, she kept the $2,500, but if there's an issue, my client should have received 60% of that. Your Honor, there was no direct child support amount, so she's not owed any extra money for September. My client has satisfied his child support obligation for August and September. I honestly don't understand the math that Ms. Corolla is coming up with when her and her attorney said that she can get $5,000 for the stock.
I recall that same argument as well, Attorney St.
Thank you, Your Honor.
It's the Kiwi stuff. I don't think.
And we had a conversation on October 4th about this as well. We can't just negate the fact that we had a conversation in October about it as well.
What does that, again, Ms. Cola Corolla, you're not owed any more money from the $5,000.
Okay, I accept that, Your Honor.
And Your Honor, the October payment of $2,814, it was to help her qualify for the loan.
I recall.
Which I did not end up needing.
Okay, well, Your Honor, now she's saying in May, I mean, and I'm going to be honest, I just think like my client did her a solid favor. Now she's saying she didn't need it, but at the time she did.
Because you were going to end up having me be homeless with the back and forth and the amount of time.
Stop. We haven't learned.
With 2 children.
We haven't learned.
Your Honor, my client.
No. As of today, 5/16, Ms. Cola Corolla, according to the orders that I have in front of me and the numbers, I don't see where he was not in arrears. He has not been in arrears in child support. But my question to you is, now that there's an IDO, you've accepted the benefit of the IDO and the money that he's giving you directly. Is there a reason why you've done that?
Yes, Your Honor, because up until just now, when he told me to let it go, I was under the impression that he was in arrears for November. I did not get a direct deposit for the IDO.
The amount that you thought he was in arrears, what amount?
$1,104, Your Honor.
So why would you take $2,500?
I didn't take it, Your Honor. It was put on a card, which I received in the mail.
You accept the benefit of it. Have you spent it?
No, Your Honor. I gave him credit in Exhibit 2 for that amount, and I'm only saying that the child support arrears is $248 based on that. But if you're telling me to let it go, then that's fine.
And let it go, because again, he was, according to the numbers, the order.
According to the numbers that I put on that chart, the child support for November, as stated per your final order, was $1,710, and he did not pay that in November.
Because he paid the 20. Okay, we're going to. Okay.
Yeah, I understand that we have a different understanding of that, and that's okay. That's why I'm here. I just want clarity. I just want clarity and to stop talking about money.
Okay, well, we can't, because I don't even know you could forego. I mean, Mr. Attorney St. Fleur, you want the IDO to stop, but don't you want verification?
I would
documentation of the IDO. I mean, of an income. I mean, what is it about an IDO that?
Your Honor,
no.
Are you asking me what
I'm sorry, Your Honor. I will say this, Your Honor, and Your Honor, you've been doing this for a long time, Your Honor. Your Honor, the IDO was done prematurely, Your Honor, and even if in her mind she said he only owed $1,100, an IDO wouldn't be in place if there was a one full child support amount. The child support amount is $1,710. So first, I mean, I'm 17, so it was done prematurely, Your Honor, and it was a thing, because I will say this: it may not have been Ms. Cola Corolla. Let me just say this, but my client received a letter from child support saying he owed $10,000 in child support. But again, that may not have been Ms. Corolla, but she did go to child support services when Mr. Corolla takes care of his children. Your Honor, I did speak with my client. He does not want the IDO in place at all, because Your Honor, he's always paid her early. And I'm trying to talk him into just keeping the IDO in place. This is one less thing we have to, he has to, but he's like, Rachel, I take care of my children. Your Honor, I will say this: being his lawyer this time, Your Honor, he's never skipped a beat with his kids, Your Honor. But because she was paid a full amount of child support in April from my client, a full amount, in May, Your Honor, she owes him $25.65. And he needs that money back, because if not, we're going to have to file another motion for contempt, because, Your Honor, she's been overpaid at this point. And then we included the $978.56 there. We included that. We took that money out. So, Your Honor, as of today's date, she owes him $25.65. That's where we are. And again, I can talk to my client again, but he wants that IDO removed because he feels as if it was done fraudulently and she misrepresented facts to child support services. Now there's a fee that comes out, Your Honor. So all the money, it's not even going towards the kids anyway with the IDO. They're missing out on about $40 a month, but yet and still she needs, we're here for $1,000. But, Your Honor, I mean, it's a fee associated when you get child support involved, Your Honor. My client, he wants the IDO to be removed. And I will add, Your Honor, she cannot say he's paid. She keeps saying the November payment was $606. He paid December on time, January, February.
I'm giving complete
April,
acknowledgement of
May.
that. That is not an issue for me.
Well, there's nothing I can do with the IDO, Attorney St. For you're gonna have to take that up with DHS, or should I say Miss Cola Corolla. I can't remove an IDO. I didn't sign an IDO. But that money that Ms. Cola Corolla, you owe Mr. Cola Corolla for the overpayment,
He can count it towards the next payment if he would like.
They can't do that because it's going to be taken out of his check automatically. Had it not been IDO, you could say, you know what, skip a payment. But now that you put in an IDO, that can't be done. They're going to take it out regardless.
Okay. I mean, if it is Your Honor's ruling that
I don't want to call it petty. I'll call it petty.
I mean, Your Honor, I'm just simply
Miss Cola Corolla. Again. So again,
okay, I would like to be solution oriented at this point. If you feel that if your judgment is that he did not miss November, fine. He does not owe me $1,104, fine. The $852 that I have received, $856, I just want this to, I don't want to talk about money. If you are not able to, or you said this is not something that is in your jurisdiction, I have to go to DCSS about the IDO. I just want to make sure I understand that correctly.
Yes, ma'am. There's nothing I can do about that. You went to DHS for that. You opened the case.
I think that would be that is my preference. I'm happy to return based on what your judgment is that he no longer owes me for November. Fine. I will return the overpayment of $856.
No, it's not $856.
That's all I've received to date, Your Honor. That is all I have received to date. I don't have anything else from DCSS.
So you didn't receive a payment of, what is that? 25, was it $25.65?
No, Your Honor. I have received $856.
Attorney St. For you have documentation or proof that's the $25.65?
Your Honor, I will say this, Your Honor. In April, can she confirm with whether or not she received a full payment from Mr. Cola Corolla of $1,710? Ms. Corolla, can you confirm?
Did you receive a payment in April of $1,710 child support?
Yes, Your Honor.
And can she confirm whether or not she received half a payment from the income deduction order in April?
In addition to the $1,710 that he already sent you, did you receive a half payment, Ms. Cola Corolla?
I received, as of yesterday, I received May 16th, I received $856. I did not receive a half payment in April.
In April, you received a half payment.
No, Your Honor, I received $856 yesterday on a gift card.
But that's
And that's for,
May.
and that's for April, correct?
May 2023 additional payment is how I have that categorized. I'd have to go to DCSS because I had to call to find out what was done. I was not made aware. I did not receive a letter. All I received was that gift card of $856.
So that's the only amount of money you've received from DCS.
And I have not cashed it. That is correct.
So you did not receive a payment in April.
I received $856 yesterday.
And so you have not received anything else for the May, because today is May
I
16th.
answered you.
She said she has it. She said she only got a payment in May, yesterday. So she didn't receive a half payment in April.
And just to be clear, did Mr. Corolla transfer you 1710 for May?
I answered that.
Did you? Well, answer it again. Did he send you, wait a minute, did he send you a 17?
Yeah, he sends it early. He sends it in May for April.
So you.
He sends early. He sends the money for the following month in the prior month.
So you did receive May child support in the amount of 1710, correct?
He answered the question.
I answered yes.
Received the $800 from DHS, Attorney
Yes.
Sanctuary.
Yes, Your Honor. So that's 856, and Your Honor, because the IDO does not end, she's going to get the full 1710 from May. Yes.
Yeah.
So
Well, Attorney St. Fleur, you know what powers you have with.
Well, Your Honor, as of today, Your Honor, we are asking for the 856. If she can transfer that to him.
The half payment.
The half the payment that she received. And then Your Honor, I guess.
Her 1710.
And exactly, I'm not exactly sure. Yeah, and we're asking for the 1710 back, Your Honor, because she's gonna get it. We're asking for the full.
She don't have it. She doesn't have it now.
Okay, well that's fine. So as soon as she receives the full 1710, we're asking that she returns it back to my client.
So at this point, the only two things we can do. She can either call DHS and close her case, or Mr. Corolla can stop paying her directly, which would be 1710. So I know Mr. Corolla wants the IDO removed. Mr. Corolla.
Yes, Judge.
Why do you want the IDO removed?
Thank you so much. Only because it was filed under false context.
But it's done.
It's the principle of it. I think
be honest, is it embarrassing that it's coming out of
yes, ma'am. Yes, ma'am. It is quite intrusive and embarrassing. I have never been late. She gets the money a week in advance. On the order you signed, ma'am, it's not due till the 15th of the month. So I have been nothing but upstanding about this. And it's, to be honest, it's embarrassing and it's unnecessary.
I understand. And just be honest with me.
Yes, ma'am. Thank you so much.
Your Honor, may I ask a question?
You can ask.
My question is that given how this has gone on, we've been in front of you quite a few times. I think that I would prefer and I would ask that it stay in place just because we would like to lessen one point of contention between the two of us in conversation. If he is okay with changing the amount in November, we have several years to go with these children in child support payments. I don't want on a whim for him to decide that he would like to lessen the amount again, and I'm before you once again. That is the only reason that I feel at this point in the conversation that it protects both of us to have this in place.
It does.
There's no more conversation about child support. There's no more conversation about how much is owed. It is in place. It is done. It doesn't even all come out at once, as I was told. It comes out in 2 separate payments. That is my only, I would prefer not to have a contentious conversation at any point for any reason with Mr. Colacarolo.
And I just think, to be honest, I'm talking to both parties, it's cleaner that way. I know it's rather intrusive, but it keeps, it puts a distance between the two of you on this issue. And you can focus on other things. So I know you don't like it, Mr. Colacarolo, but in order to be cleaner and again, distant regarding this issue and this issue only, I'm going to keep the IDO in place. However, Miss, you owe him some money.
And I'm based on what you've said here today, I will return the overpayment of $1,710 once I receive it.
You're in the 856.
Yeah, he gave you 17.
The 856 is a part of the $1,710.
You're
No. So you're gonna, so because the IDO, don't forget Ms. Colacarolo, you're gonna get 1710 that he's already given you.
Yes, 856 is half of what I'm going to be overpaid.
Right.
Yes, so I only owe him $1,710 of an overpayment for May.
She owes him April as well.
I do not owe him April because I received no money. I received money in April, but not an overpayment in April.
You're under the check.
There's no documentation of that. I only received $856 from child support.
Stop. She said she didn't receive any money in April.
Your Honor, I think they're a month behind, Your Honor. That said he gave her 1710 in April. I think the card she received is for 856. And I
called child support office last week. It's $856 on that card.
My paycheck was deducted in April. I have 2 paychecks, mid-month and end of month. And it came out of the end of month April check, and it said April child support.
Mm-hmm.
And it's come out on my May 15th check, which, I saw the pay advice last week, Friday. It said, May child support, first part. So in essence, she's already gotten May from me cash. She's gotten April cash. Right. So she owes me.
I owe you the overpayment in May. I did not receive anything in April.
But it was Colacarolo. It was taken from
I am more than happy. Once again, I don't want to be overpaid. I just wanted what I was due. I will check with DCSS. If I've been paid on that card, $1,710 in addition to $856, I will give it back to him. The point is that I don't want to have conversations with him about child support. So I'm more than happy to return it. I don't want more from him. I want exactly what you've ordered us to receive. That is it.
Your Honor, if I may speak, I understand that, I understand your comment on, it's one less point of contact. But I do want to say that, I have never been late.
Well,
the Zelle transactions,
it doesn't matter.
The Zelle transactions show that I actually have always paid these in advance. And
you change them out at will.
Colacarolo, stop.
I apologize, Your Honor.
You always have to stop.
I understand.
And I think if I have no reason to hold any support back to my children or to her.
Colacarolo, stop. Not necessary.
So I would really appreciate if you would consider.
Stop.
Yes, ma'am. Yes, ma'am. Yes, Your Honor.
Ms. Colacarolo.
Yes, Your Honor.
If you said you were not paid in April, Mr. Colacarolo says that it was taken out of his check. It's going to be incumbent upon you. I'm just
understood, Your Honor.
Otherwise, what's going to happen. Attorney St. Fleur is going to file a contempt.
I know.
And we're going to be right back where we are right today.
I have no interest in it. I've never taken more.
You know that's what's going to happen.
I do. I know him very well.
So
and I have no interest. It would be incumbent
upon you to get in contact with these DHS. If they paid you, just tell them, look, I didn't get the 856, or I didn't get the 1710. Even though my ex-husband's reporting that was taken out of his check. And they're gonna have you in court because Attorney St. Fleur is gonna file a contempt.
I am interested in the truth just as much as they are. I don't have it. If I do get it, or if I will get it, then I will return it.
And Mr. Corolla, you can also call DHS and show them that it came out
sure
of
can.
check. Can you go online to see? Well, he said it was taken
No, it's not set up for online because of the DV.
Okay. So he can't see. So again, Mr. Corolla, you can go to DHS as well and let them know.
Yeah, it's flagged for DV, so I have to do everything in person just like he does.
So I know that's, again, time and effort.
Your Honor, may I just say something,
No,
Your Honor?
you may not. You may not.
Well, may I request attorney fees, Your Honor, or have?
No.
Your Honor, it was a
You can
fraudulent.
make a request.
It was a fraudulent motion for contempt, Your Honor. I had to prepare for this, Your Honor. We've been in court for 3 hours, Your Honor, for a matter, Your Honor, that's clear in the transcripts, Your Honor, that
It
all
wasn't.
September.
Miss Corolla.
And Your Honor, it's just, I mean, we've literally been here for all, she's saying that September child support wasn't paid, Your Honor. My client did not have to retain me for this. Like, this is money that's taken away from his children.
Okay, well, all behavior and actions have consequences. Miss Corolla, that's you too.
And I really do think that attorney fees need to be awarded to my client at this point, Your Honor, because he's not the one being found in contempt.
He's no one. I'm not asking. I denied the contempt. I didn't say that earlier.
No, you did, Your Honor, before there. And in our response, Your Honor, we did ask for. We did. I think our answer was very solid, and I think that we should that he should be awarded attorney fees. Your Honor, she can go file an IDO on her own and do things. She
has a right to do that. She can do that.
She has a right to do that, Your Honor. But the child support addendum states if he was behind, Your Honor, he was never behind.
Well, it was her understanding that he was.
It wasn't a full child support payment either, Your Honor. It was alleged.
We're going to move on, counsel. We're going to move on. Once again, I'm asking, imploring, encouraging that both Mr. Corolla and Miss Corolla, please. All of this is not necessary. It's not. And just because you have the power or the authority to do some things doesn't necessarily mean you must use or utilize that power. And just because someone says something or does something doesn't always warrant a response. All I'll ask is that both parties give each other what they would like to have when it comes to this very difficult situation. There's a little bit of grace. Actually, a lot of grace, a lot of patience. Because at the end of the day, it's not about you two. You guys have decided to move on separately on your separate path. But your children, that should be a priority. That's it. That's all.
Your Honor, when can Mr. Corolla expect the 856 back? Because she has it on the card.
St. Fleur, didn't I tell you you couldn't say anything?
Oh, no, I thought you said I couldn't say anything about the attorney fees.
You can't say it. No, stop talking. Ms. Corolla is going to go to DHS to make sure, confirm payments of the 856 back in April. And once she does that, I'll give her to the end of this month, Ms. Corolla.
Yes, Your Honor, I can do that.
To submit that payment to Mr. Corolla, okay?
Yes, Your Honor, of $856 and
Well,
anything
it
else.
might be more. It might be
Anything else.
more.
Okay,
Okay,
by the end of the month, understood.
by the end of the month. Okay.
So may I clarify? So June payments will be intact as they are through DCSS.
Everything is coming through DHS from this.
Okay, thank you, Your Honor.
So, Mr. Colacor, you don't have to do any Zelle. Okay. All right.
Yes, Your Honor.
Focus on your children. All right.
Yes, ma'am. Thank you.
How are you doing, Mr. Colacor?
Better than I deserve.
I think that's all of us, actually. Okay. And before, Attorney St. Fleur, before you file, I don't need a response. I would ask that before you file, should Ms. Cola Corolla not do as is instructed, that you give her a little grace, maybe a week or two, not June 1st. Just letting you know now. Okay. All right. So is there anything else? Yes, Ms. Cola Corolla.
I just, not an attorney, just want to make sure I understand. We're creating the personal finance is a wash. I just don't want to have that come back to me as well.
What do you mean a wash?
As far as we're considering the equity and the payment of the GAL and Range Rover to be a wash at this point. So he doesn't owe me and I don't owe him. We're done with that.
Well, I'm at this
You
point.
told me to let it. You told me to let it go. So I just want to make sure.
Attorney
Okay.
St. Fleur, is that an issue?
No, Your Honor, it's no longer an issue, Your Honor.
Okay, it's a wash. Everything.
Thank you. Net
Okay.
neutral zero.
Wait, I see Mr. Corolla now. Yes, Mr. Corolla.
I just want the overpayments and child support returned. So once she clarifies that, I want the funds returned.
Okay.
And the legal fees. And the legal fees.
Well, you're not getting legal fees, Mr. Cola Corolla.
Your Honor.
No, I know.
Your Honor, may I just make one comment real quick?
Yes, sir, you may.
I'm the one in a position, I'm the one that has to provide to these children. Ms. Corolla had a year to find work. She still hasn't found appropriate work. I'm still providing as necessary.
As you should.
And I'm happy to do it. I want to make this clear that I'm happy to do it and more.
Okay.
I am happy to do it and more. Mm-hmm. But this is honestly a waste of, the court's time and my limited resources. And, it sends a message if you tell her that not to pay for my attorney fees. I have kept quiet while this woman has financially abused me in the last 6-7 months. And she's able to keep doing that and get away with it. Your Honor, what would be fair to me is if everything got reversed, but I understand limited contact is better. At minimum, she needs to pay my attorney fees.
What kind of attorney's fees? Wait, I'm talking to Mr. Cola.
Yeah.
I'm talking to Mr. Nobody else talk. Mr. Cola Corolla. What kind of fees are you asking for? I'm asking.
I retained attorney St. Fleur for this engagement for $3,500. And it's a matter of, Catherine came here on a matter of principle, on false pretense. That's a waste of hard-earned resources.
Well, you're thinking she came false, but she believed that she was owed money that you had not paid.
I'm not sure that's actually the case. She's not been very transparent about her reasonings.
No. And
it is unfair to me to have to, put up with this consistently. It is unfair to me. A year after, I'm still trying to like rebuild. I'm still like, and it's unfair to me that she can just decide to file a motion for contempt, putting that I should be arrested for partial on payments.
Okay. Attorney Stanford, under what statutory basis are you requesting attorney's fees?
Your Honor, Your Honor, the courts can give me 5 days to look it up, Your Honor, make sure that it's appropriate. I could provide that to the court. Actually, I can provide that to the court by the end of the day.
Okay, all right. I'll review it.
Thank you so much, Your Honor.
All right. Nothing else. All parties are excused. Make your children your priority.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Everyone's excused.
Thank you, Judge.
Be safe. All right.